Welcome to this seminar, Radcliffe Chambers Charities webinar. I will be talking about case updates, recent cases decided in the last year, and my colleague Matthew Mills will be doing effectively an overview of the COVID-19 guidance as it pertains to charities. I'm now going to do the litigation update. And I'm happy to say that there haven't been too many charity cases in the last year. I'm going to talk about 3 of them. I'm going to talk about the David Roberts Art Foundation and Radcliffe, Charity Commission and Wright very briefly because time is limited and it's a relatively straightforward case, but I just wanted to alert you to it. And for Phalias and Apodiakos, which is a relatively recent decision. So I will talk about the David Roberts Art Foundation case first. It's a cautionary tale, as so much litigation is. A relatively minor error has led to quite significant consequences in litigation. The decision was of a summary judgment application by a charity vendor in a claim for damages for failure to complete a purchase. And the relevant facts, as briefly as possible, there's property in Camden Town in northwest London. In November 2016, it was marketed by the charity freeholder. In December 2016, the purchaser bid for it and heads of terms of a sale were agreed, subject to approval by the charity trustees. And at that point, in January 2017, the trustees obtained a surveyor's report under section 119 of the 2011 Charities Act, 1191A. This valued the property at £7.5 million. It wrongly stated that the property had already been marketed for 3 to 4 months. It advised that 6 months marketing was sufficient, but it didn't give any advice about advertising the property, which is a requirement in section 1191B. Then on the in May 2017, contracts were exchanged. There was no order from the court or the commission. The price was 8.01 million. Part of the deposit, 410,000, was paid. There was an original completion date of 31st of October 2017. There was no completion. The parties agreed to vary to set a new date, 15th of December 2017. No completion. Charity served notices to complete on the 15th of December and the 5th of February 2018. On the 23rd of February 2018, in the absence of completion, the charity sold the property to a third party for £5.5 million, and then served notice of rescission and a letter of claim on the purchaser. So the claimant issued a claim for the declaration that there had been a rescission, forfeiture of the deposit, payment of the balance of deposit, and damages for the loss of bargain. The purchaser's defence and counterclaim was to the effect that the contract was unenforceable because there was no statement in the contract under section 1222 of the 2011 Act. And it put the claimant to proof as to compliance with the section 119 requirements, which enable the sale without an order of the court or the commission. The claimant then amended, didn't argue that there was a valid statement in the contract under section 1222, but pleaded that a failure to comply with that requirement did not render the contract unenforceable, and then pleaded rectification of the contract in the alternative. And the relevant provision of section 122, subsection 2, requires an instrument which would include a contract for the sale of land to state that the land is held by or in trust for the charity, whether or not it's an exempt charity or any of the exceptions apply to the disposition, which to another charity for less than the market value, and there are various exceptions. If it's not an exempt charity and that none of the exceptions apply, the land is land to which the restrictions on disposition imposed by sections 117 to 121 apply. And it's also noteworthy that section 1231 says that when it's going to be a registrable disposition, the statement required by 1222 is to be contained, that must be in the instrument, must be in a prescribed form. And in the judgment, Master Marsh at paragraph 14 says that there's no current prescribed form. Well, I respectfully disagree with that, because Rule 181C of the 2003 Land Registration Rules prescribes a form of wording under section 37(1) of the 1993 Charities Act. And it refers to the various sections of the 1993 Act that are comparable to Part 7 of the 2011 Act. They're substantively identical to the new Act's provisions. And as many of you no doubt know, the 2011 Act was a consolidating Act. So it consolidated the 93 Act with the 2006 Act and some other acts. So it's effectively the successor to section 36 that we're dealing with here. And Schedule 8, paragraph 3, subparagraph 1 of the 2011 Act says that a reference, express or implied, in any enactment, instrument or document to a provision repealed by this Act is subject to its context to be read as being or including a reference to the corresponding provision of this Act in relation to time, circumstances or purposes in relation to which that provision has effect. And Section 17(2)(b) of the Interpretation Act 1978 preserves the effect of subordinate legislation when an enactment is repealed and reenacted. So as I said, I respectfully think that Master Marsh was wrong, that you must use the Rule 180 form, but changing the references to the 93 Act for the relevant references to the 2011 Act. And the form of the statement in the contract is on your screen now. My version of what would have been a properly compliant statement according to the land registration rules is at the bottom of the screen. So you can see that the statement as used, which was in a draft transfer annexed to the contract, not in the body of the contract, did not fully comply with section 1222, and it certainly wasn't in the form prescribed by the rules. So the decision on the section 122 point was that incorporating it by reference to the draft transfer did constitute inclusion in the contract for section 1222. For the purposes of compliance with the section, it suffices if the contract contains the information in a form that can be understood on a careful reading of it. And the transfer was an integral part of the agreement, so it's in the contract. He then said, Obiter, that the wording in the draft transfer wouldn't satisfy section 1222, probably. He didn't have to decide it, so he didn't. But crucially, the requirements of 1222 are subsidiary to the principal Part 7 requirements, i.e. the substantive requirements in section 1191 in this case. He pointed out in paragraph 88, there was no protection for a purchaser for non-compliance with 1222, as opposed to the requirement in 1223 relating to the instrument affecting the disposition, so the transfer in this case, if it had happened. There is protection for purchasers for non-compliance for that one, but not for failing to include it in the contract. And ultimately, he decided that non-compliance with section 1222 did not automatically amount to unenforceability of the contract. And again, Obady said, considering the rectification point, that if he'd had to consider that, the defendant would have had a real prospect of defending the rectification claim. He said that the claimant's evidence was inadequate and that there was no basis for an express common intention to include the section 1222 statement. Now, again, I respectively question the correctness of that analysis, because what the parties must have had a common intention, or must be assumed to have had a common intention, was to enter into a valid contract. And if it needed prescribed wording to be valid, and the parties mistakenly thought that the certificate in the transfer was sufficient, then I would suggest the door should be open to rectifying to include the section 181C of the rules wording, because that by statute is what is necessary to comply with the rules for a valid contract. The parties must have been intended to create a valid contract. They must have been intending to include that wording. So turning to the separate question of the section 119 requirements, as are well known to those who regularly deal with the sale of charity land, you need a surveyor's report. The trustees must advertise as advised in the report, and the trustees must decide that they're satisfied that the terms are the best that can reasonably be obtained for the charity. And section 1194 says that regulations can prescribe the contents of the report. There are regulations, the Charities Qualified Surveyors Reports Regulations 1992, 2980, which continue to apply. There were issues with compliance in this case. Property was marketed before the surveyor was instructed, so not in accordance with the report advice. No prospective advice about marketing, no advice yet about the need to advertise. Property wasn't advertised. There was inadequate evidence that the trustees had considered the report or the way in which they did so, and inadequate evidence that they were satisfied that the sale was on the best terms that could reasonably be obtained for charity, and there'd been imperfect compliance with the regulations, which deal with sort of practical questions like, is the property subject to easements? Is there VAT on the purchase? What sort of state of repair is it in? The decision on section 119 was that, again, failure to deal with specific items in the regulations did not automatically render the report non-compliant. But at paragraph 94, there's a very useful summary of the process that trustees ought to follow. So they consider making the disposition and then choose to follow the section 1191 process if they don't get an order. They get the report in the specified form. They need not have a specific transaction in mind, just an intention to dispose of the property. But it could be triggered by an unsolicited offer. The report should advise on the period of advertising, the manner of advertising, or advise that it's not necessary to advertise, deal with the regulations requirements. Trustees consider the report. Property is advertised unless it's not necessary or it has been advised not to be necessary. Prospective purchaser makes the offer. Trustees decide whether they're the best terms. Consider the report in light of this test. Again, maybe require supplemental advice, etc. In this case, the trustees failed to comply with the advertising requirement. The Section 119 requirements are a different class to Section 122, so failure to comply prevents a valid disposal. But if taking an overview of the matter, a step that's admitted that is really pointless, it wouldn't invalidate the sale. Here, the failure to advertise may not invalidate the sale. The key is if the disposition is on the best terms reasonably available. And there needs to be cogent evidence of this, and that advertising would have made no difference. If there was that evidence, or if that evidence becomes available, the failure to advertise and getting the report out of order would not invalidate the contract. So Master Marsh didn't feel able to grant summary judgment. There needed to be a further factual inquiry. So I would respectfully agree with Master March's approach here. The regime is there to safeguard charity property. Purchasers shouldn't be able to weasel out of good deals due to technical breaches by the trustees. Substantial compliance with the Part 7 requirements should be enough. This is a useful guide to what trustees need to do. But please do use the prescribed form in Rule 180 of the Land Registration Rules 2003. So that's David Roberts Art Foundation and Rydwig. Charity Commission and Right, I'm going to talk about that very briefly. It's a case about committal of charity trustees for failing to provide information in the course of a statutory inquiry. There's a power in Section 47(2) of the 2011 Act for the Commission to direct people to provide certain categories of information, accounts, statements, documents, and also turn up to give evidence once a statutory inquiry has been launched. In this case, directions were made, there was no certainly inadequate compliance, and the Commission sought to commit these charity trustees, and they didn't turn up to the committal hearing. And the judge decided that the Commission has the burden of proving non-compliance, and it must prove it to the criminal standard. Where there's failure to provide a document, where that's alleged, the Commission must prove the existence of the document beyond a reasonable doubt. And they didn't do that for every document in this case. And they can't rely on a failure by the trustees to assert that a document doesn't exist when it's requested. The judge did find that various breaches by the trustees were proved, and he gave guidance in paragraphs 41 to 51 on the court's decision whether or not to proceed in the defendant's absence, and he decided that it was appropriate to do so. And that, for example, issuing a bench warrant would be more punitive than simply making the decision in their absence. So it's useful guidance and a useful reminder of the penalty for non-compliance with the Commission's directions. Turning to the third case, for Falias and Apodiakos, this was a claim by trustees of one charitable trust, the Cathedral Trust, or a declaration that another charitable trust, the Cemetery Trust, held surplus assets on trust to be applied in accordance with resolutions of a separate unincorporated association, or they sought a scheme for the same effect, and they sought a declaration as to the identity of that unincorporated association. So a bit of background: the Greek community in London was formally organised in about 1839, and the Cemetery Trust was created by a deed of 31st of December 1860, and on the screen you can see the operative provisions of the deed. So there wasn't a lot to it, and there wasn't much in the way of administrative provisions either. There was some stuff about appointment of trustees, but beyond that it was very much left to the making of rules and regulations. Then in 1935, the then trustees purported to make this declaration of trust, and they recited that the 1860 deed made no provision in respect of the profits earned by this cemetery trust, but they had certain monies in their hands from the sale of graves, and they didn't know what to do with them. So the operative provision is there on your screen. This other trust was formed in 1888 to run the cathedral that did have a factual connection with the cemetery. There's no evidence, definitive evidence, that the 1935 power was ever used. But then in 2014, there was an AGM of the assembly connected to the cathedral that made a resolution that the cemetery trustees should transfer £200,000 of that trust's money to the cathedral trustees for investment. And the cemetery trustees refused. They said the assembly had no authority to do that. The cathedral trustees said they had authority from the 1935 declaration, and that the assembly was the Greek community in London that had the power to make these directions under the 35 deed. The cemetery trustees said the 1935 declaration of trust was invalid, and that the Greek community in London was a separate body that had been dissolved by the end of World War II and was not the assembly. So this came to court. The cemetery trustees argued that, applying the usual rules of construction, there was no power for the trustees to make the 1935 declaration. The 1860 deed set out the charitable purposes, and this was an impermissible alteration of the purposes. The cathedral trustees argued that because the 35 declaration had been treated as valid for 80 years, it shouldn't now be held invalid. And they relied on a case called the Attorney General and Sydney Sussex, which provided that obiter, that you should adopt a construction that means trustees are not committing a breach of trust from the commencement of the trust to the present time when considering the meaning of a trust deed. They also relied on two of the principles in a case called the Attorney General and Matheson. One is that the trustees can't challenge the validity of a trust deed under which they're acting. And secondly, that where trusts are, where property is given for charitable purposes, but indefinite purposes, the trustees to whom the property is given then have to declare the purposes, and can do so. And they have implied authority to do so. So the cathedral trustees were saying that the 1860 deed had a lacuna that brought it within this principle, that there was an implication that the cemetery trustees had to declare what to do with the income. And they made the 1935 declaration. And the judge held that he accepted the cemetery trustees' arguments that the Sydney Sussex principle applies where there's ambiguity, But there wasn't an ambiguity here. The deed of 1860 was clear as to what it meant. The first principle in Matheson applied to the original terms of a trust. So it didn't preclude trustees from challenging subsequent changes to terms of trusts. And the 1935 declaration was not part of the original terms. There was no power in the 1860 deed allowing the 1935 trustees to make the 1935 declaration. There was no gap in relation to the trusts of income. They're the same as the trusts of capital. The second Matheson principle can't be used to introduce inconsistent provisions that are inconsistent with the original trusts. And that's what the cathedral trustees were arguing here. And they can't make unilateral determinations of purposes. The original purposes must be respected. He also agreed that the 1935 declaration was void for uncertainty because there was absolutely no limitation on the purposes for which the money could be applied at the direction of the Greek community. So there was no restriction to charitable purpose. He also considered dicta to the effect that if there's a choice between a non-charitable and a charitable interpretation of purposes, you choose the charitable one. They had no application to this case as there were no specific purposes in the 1935 declaration. He then went on to reject the claim for a CPRE scheme that had the effect of the 1935 declaration because neither the CPRE occasion under 62(1)(e) of the 2011 Act that the trust ceased to provide suitable and effective method of using the property, or 62(1)(b), which dealt with surpluses, that neither of those occasions had arisen. Although he warned the cemetery trustees that they had to review their sort of reserves position very carefully because they did have quite a lot of money held on reserve. So this case is an indication to advisors of charity trustees and indeed charity beneficiaries that they shouldn't take for granted the validity of any trust deed, however old it may be. And it also shows the importance of sticking rigorously to the terms of governing documents when trustees are exercising powers. And I would just leave you with one thought, which you may want to raise in the question section. What do you think the costs order was in this case? And with that, I will hand over to my colleague Matthew to talk about COVID guidance and its application to trustees.
Great stuff. Thanks very much, Josh. And good morning, everyone. My name is Matt Mills, and I'm here to talk to you about recent charity guidance. Now, in the last 4 months, there has been a lot of charity guidance out there from the government, the commission, charitable organisation, lawyers, and pretty much anybody with a blog. And I can't promise to cover every single thing in this short talk. But what I can do is promise to cover about 60 different websites which give COVID-related guidance and try and consolidate them into a useful structure. Don't worry about making notes. After this is finished, you'll be sent the slides which contains all the links that I've used to rely on. I'm sure we're fed up of being told what we can't do. So what I decided to focus on in this talk is what we can do. And I'm going to focus on 5 things that charities can still do. Firstly, I'm going to give a brief outline of the general sources of guidance open to charities. And secondly, I'm going to talk about how charities can and should be managing their finances at the moment, what things charities should bear in mind when running their day-to-day business, how they can host or postpone AGMs, and how they can reopen their shops safely. Before I turn to the nitty-gritty of those last specific issues, I thought it would be useful if I told you the list of websites that I found most useful when I was writing this talk. There are 3 of them. Firstly, of course, the starting point has got to be the Commission's latest COVID guidance. But you could also consider the guidance from the Charity Commission for Northern Ireland, which is broadly similar, but not exactly the same. Finally, in my view, the NCVO has produced probably the most helpful non-governmental set of guidance for charities. But if that's not enough guidance for you, here's a list to a very long list of other different guidance sources that you can find. But whatever source you use, when reading any guidance at the moment, it's important to bear in mind the Commission's general approach. Here it is. In a nutshell, the Commission will try to do what it can to help charities in these extraordinary times by being as flexible as possible and as pragmatic as possible. With that out of the way, let's turn to our first substantive topic, finances. One of the major concerns for pretty much any organisation at the moment is money. In particular, in a survey conducted just last month, it was found that during lockdown, on average, charities received 29% less income than they budgeted for. 84% of charities reported a decrease or significant decrease in their total income, and 92% of charities reported a fall in trading. So with that rather doomy and gloomy background, I'm going to talk to you about three things. Firstly, how charities can still make sensible financial decisions. Secondly, how charities can secure further income. And thirdly, how charities should be reporting their finances right now. So let's turn to the first of those topics. When making a financial decision, the starting point is still CC12 on managing a charity's finances. But the Commission has provided some further COVID guidance. As always, the overarching principle is that trustees must do what's in the best interests of the charity. However, specifically, the Commission has suggested a four-step approach to making financial decisions right now. Firstly, a charity should consider the current financial position very carefully. For example, cash flow over the next 6 months, what payments must be made, what income is realistically going to come in, and what cash the charity currently has. Secondly, a charity should consider ways to try and minimise its costs, if possible. For example, by reviewing non-essential outgoings, or finding cheaper versions of existing products, or moving staff to key financially impactful areas, or even considering teaming up with other charities. Thirdly, a charity should consider ways to conserve or ideally increase its income, and I'll talk about that in a minute. And fourthly, a charity should keep everything under constant review. Now, that's all very well and good in theory, but how can a charity realistically raise money right now? I'm going to give you 5 suggestions for how they can do it. Firstly, charities could try to repurpose some of their existing funds. In this context, the Commission has suggested doing 3 things. Firstly, discussing with any funders early on to see if they'd be willing to relax any of the restrictions that were placed on donated funds. Secondly, and relatedly, a charity could consider lifting any restrictions that it itself put on the funds that it wants to use. And thirdly, as a last resort, a charity could even consider using its endowment fund. However, a charity should consult the Commission before taking this drastic step, because it is, as I said, very serious. The second way that charities can raise funds by now is by selling assets or investments. In this context, the Commission has again told us that charities should bear in mind 3 things. Firstly, unsurprisingly, charities must expect that they'll raise less money now than they would in more normal times from a sale. Now, it may still be in the best interest of the charity to sell something at a lower value than usual, but if it is, the trustees must make sure they have good reasons for this and record those reasons in writing. Secondly, charities should at least consider whether they can borrow against the assets rather than sell them at a reduced price, because that might later allow them to be sold at full value. And thirdly, if the charity does need to sell assets, it must bear in mind that in certain cases, for example, for the sale of land, there'll be procedural hoops and restrictions that need to be gone through before the sale can take place, and that might impact timing and even price of the sale. The third thing that charities can do to raise additional funds is, of course, fundraise. Now, in reality, the changes here are pragmatic and legal. Practically, lots of people have much less money than they did before lockdown and will simply be less willing to give money to charity. On top of that, in-person fundraising is pretty much restricted for the medium term. Nevertheless, the Institute of Fundraising has provided various practical tips on how charities can start remote fundraising appeals right now. It's all mostly common sense stuff. For example, charities should focus on a specific need that they want to fulfill. They must be transparent about what their funds are going to be used for, and in particular be clear about the deductions that will be made from the donated funds to things like legal costs or administrative costs. On top of that, as face-to-face fundraising is pretty much out of the question, charities need to bear in mind that they should comply with the Code of Fundraising Practice when dealing with non-direct forms of marketing, like email, telephone, text, or post. And I'm afraid to say it, charities mustn't forget GDPR. I know GDPR is probably everyone's worst nightmare. We're sick to death of hearing from it, but it is unfortunately important stuff, even during the pandemic. The fourth way that charities can try to raise money now is by looking into any claims they might have under their insurance policies, particularly business interruption insurance or similar policies like that. As you might expect, insurers are pretty much doing everything they can not to pay out on these insurance policies, but it's certainly worth checking. And even if your particular charity's insurer is not willing to hand over money right now, that might change in the coming weeks. Firstly, the Hiscox Action Group has been set up by about 600 companies who want to challenge Hiscox for refusing to pay out on business interruption insurance. They've instructed Mishcon de Rea, and the matter's proceeding to court. Secondly, and more importantly, the FCA has reviewed over 500 insurance policies from 40 different insurers and come up with 17 clauses that reflect the general trend across those insurers, and has referred all 17 to court for a test case next week and the week after, basically to decide whether the insurers are liable to pay out for COVID losses or not. If you think either of these are relevant to your client, it's worth checking out those links there to see how things progress. The fifth way that charities can raise money right now is by looking into grants or loans from other organisations. Now, there are lots and lots of sources out there, but I've summarised basically two tables: governmental and non-governmental grants that are still open and substantial. Here's the list of government grants. I'm not going to take you through it because that's far too much detail, but you get the general gist. If you look in the middle, some of them are very specific, for example, for zoos and aquariums, but others are very general, like at the top, the Coronavirus Community Support Fund, which incidentally is likely to have a further 110 million put into it in the near future. Also, don't forget that charities are allowed to take out a coronavirus business interruption loan. Now, profit-making organisations must show that 50% of their total income comes from trade to be able to get a loan, but HMRC has waived this requirement for charities. However, before taking out any loan right now, a charity must bear in mind, firstly, that its governing document needs to authorise the trustees to do this. And secondly, the charity needs to make sure that they will realistically be able to pay it back. Because taking out a loan, particularly with a higher interest rate now, that they know they're not going to pay back, is really just storing up more trouble further down the line. Also, if your client is considering applying for government funds, please remember this paragraph from the government's guidance. In a nutshell, charities must specify on each application form which other forms of public funds they've applied for. If you don't and you get more than one, the government can in theory claw it all back, so please be transparent. In addition to government funds, there are also various large pots of money from non-governmental organisations. Here are some of the bigger ones that I could find. Again, I'm not going to read it all out to you, but you get the general idea and you'll get the slides afterwards. Some of these are more specific, others are very general, but there is quite a lot out there. Let's now turn to financial reporting, having talked about raising money. And there are 3 points I want to mention here. Firstly, the Charity Commission has explicitly said that charities can ask for more time to file their annual returns this year. All they need to do is send an email to the email address that's on the slide. The Commission hasn't said how long that it will give by way of extension, but the Corporate Insolvency and Governance Act has given companies an extra 3 months in almost every case to file their returns, so I imagine you'll get something similar from the Commission. The second point on financial reporting is that the charity SORP has given detailed advice on how charities could explain the impact of the pandemic in their as of yet unfiled annual returns, basically bringing them up to date even where this isn't strictly necessary. The third point on financial reporting is that the Commission has given guidance on when charities should report serious financial incidents right now. It's given 4 recent examples. Firstly, and contrary to the general rule, if a charity's income drops by £25,000 or 20%, this is no longer in itself an automatic reason for financial reporting. Instead, the key criterion for the trustees to bear in mind is whether the losses have caused a significant impact on the charity. Now, it's quite hard to know what significant impact means, but in my view, it probably isn't that much more than a loss of 20% of income. That said, the Commission will bear in mind that, as I said earlier, charities have generally faced a 30% drop in income, and it's probably not expecting every charity to financially report, because that would just be administratively unworkable. So you're probably looking at something like 20 to 30%. More specifically, a charity should report a serious financial incident if it cannot afford to provide vital services to at-risk beneficiaries at the moment, or if the charity is insolvent or forced to close permanently, or it's likely to be insolvent or forced to close permanently in the next 12 months. Now, these are the current examples given by the Commission. The Commission has said it plans to give more examples at some point, so keep an eye on that link if you're interested. So that's all the finance stuff I wanted to talk about. Let's now turn to the day-to-day activities of charity, and I'll briefly mention 7 practical things. Firstly, what can a charity do if it wants to try to branch out and help with the pandemic? Yet again, the Commission's given guidance. And in essence, in this situation, a charity should do 2 things. Firstly, the trustees should consider whether the objects of the charity allow the charity to get involved. This could be directly, for example, if the purposes expressly cover the relief of poverty, the advancement of health, or something like that. Or if the objects allow indirect help, for example, by supporting religious pastoral work, or generally supporting a local area. Secondly, if the objects do not allow this, then the charity will need to consider whether it can amend its objects. Now, a charity should think very seriously before doing this, because it is obviously a big step, and in any event, it should follow the correct procedure. But it's something to bear in mind. If a charity does branch out into COVID-related work and wants to give grants to needy individuals, the Association of Charitable Organisations has published some useful guidance on how to do this. I've summarised it on the slide for you, but in essence, the association suggests that the entire process from application to granting to review should all be decided before money starts going out the door, just to ensure that everything is in order. The next issue is furloughing. Although the furloughing scheme closed to new employees, many charities have taken advantage of it. For example, by the start of May, approximately 164,000 charity staff members had been furloughed across the country. The most pressing question, though, for charitable trustees is likely to be, can their furloughed staff members still volunteer for their charity? The answer is no. The purpose of the furloughing scheme is to protect those who would otherwise be made redundant. It's not simply to subsidise business generally. However, furloughed employees can volunteer for other charitable organisations as long as there's no swap arrangement in place between the 2 employers, because that would likely be seen as an abuse of the scheme by HMRC, and you'd risk having the money for your furloughed staff member clawed back. On that note, various websites have been set up to help charities find furloughed staff from other organisations to support their work. Here's a couple that I found quite easily. Similarly, other websites have been set up to put charities in touch with local businesses who are willing to donate time, items, or services. Again, here's another couple. These are easy ways for a charity to obtain some free support from the local area without having to unfurlough their staff and start paying them. The next issue is gift aid. In reality, the majority of in-person events have probably been cancelled for the next few months, but some charities might quite rightly wish to offer refunds to their ticket holders. But in return, some of those ticket holders might be willing to give their potential refund back to the charity as a donation. The key question is, would that return of the donation amount to a gift aid transaction? Historically, the answer would be no, because gift aid cannot apply to a loan waiver or debt loan conversion. Now, to get around this, what charities would typically do is undertake the process in 2 stages. They give the refund in full, and then hopefully receive the donation back in the exact amount from the ticket holder. Now, that's obviously more time-consuming, administratively onerous, and simply risky, because the ticket holder might just forget or change their mind. But fortunately for charities, HMRC has now issued guidance confirming that gift aid can apply to a refused refund at the moment, without needing to go through a two-stage process. However, there are three caveats to this. Firstly, the charity must follow fairly prescribed steps. They're summarised on the slide, but you can get more detail by following the link. Secondly, this guidance only applies to cancelled events. It does not apply to postponed events. For postponed events, you still need to resort to the original two-step process. And thirdly, there's no official deadline for when this measure might expire. It's described as temporary on the government's website, but we've got no further information. So if your charity does want to rely on it, do check that this is still in force at the relevant time. Moving on, the pandemic has forced all of us to use more tech in our lives, hence webinars like this. Fortunately for charities, lots of big companies are offering their products for free to non-profit organisations. Here's a list of some of the big providers that I could find. You'll see Office 365, Dropbox, cybersecurity software, and legal products. There are almost certainly lots of others, but I just wanted to give you some idea of the range and quality of products available to charities right now for free that can help them keep going. My final topic of day-to-day life is a bit of a downer, I'm afraid. Unfortunately, police have reported an increase in coronavirus-related scams on charities. In response, the government has given some useful reminders on how to avoid the main types of fraud. This guidance is both in a written form and in a webinar. And it's, as usual, all common sense stuff, but I've summarised it for you on the slide. In a nutshell, it's things like running unfamiliar requests past colleagues, carrying out due diligence on potential new suppliers, and ensuring there's dual authorisation for any substantial financial transactions. My penultimate topic of this webinar is charity AGMs. In reality, in-person AGMs just aren't possible for a lot of organisations right now. So this is what we might be looking at for our meetings in the near future. But what concrete guidance is there out there for charities? Firstly, as to unincorporated charities, the Commission has given some relatively brief but useful guidance here. It's on the screen. In a nutshell, there are two key points, and I've underlined them both. Firstly, trustees should carefully review their governing documents to see if they can either hold meetings remotely or amend the governing document to allow remote meetings. However, in this context, please bear in mind that as a matter of law, a meeting is an event at which you can see and hear people. So a telephone conference call is not necessarily a meeting as a matter of law. The second underlying point is that even if the governing document does not allow remote meetings, and even if the governing document cannot be amended in time or at all, the Commission has said it will take a lenient view of unofficial AGMs, provided the trustees can show that this was part of the good governance of the charity. And in practice, what this means is having good reasons for doing a remote AGM, recording them in writing, and keeping good records of the meeting. As to incorporated charities, the position's clearer. Schedule 14 of the Corporate Insolvency and Governance Act 2020 applies to charitable incorporated organisations, registered cooperative societies, and community benefit societies. The key parts are paragraphs 3 and 5. In a nutshell, these allow companies to hold AGMs remotely and/or postpone AGMs up to the 30th of September, regardless of what the Constitution says. Importantly, the Act is intended to apply retrospectively, as if it came into force on the 26th of March. However, from what I can tell, the government isn't guaranteeing this. In its Q&A on the draft bill, the Department for Business, Energy and Industrial Strategy said, while it is our expectation that the legislation passes into law and applies retrospectively, we cannot guarantee this outcome. Therefore, companies and other bodies will need to take their own view on how to proceed. Now, technically, what this might mean is if a charity postponed its AGM before this Act was passed, then that could be a breach of the principles either of law or in their governing document. Now, obviously, charities shouldn't be cavalier here, but in my view, hopefully, there shouldn't be too much to worry about. Firstly, we've seen on the previous slide that the Commission is going to generally take a lenient view on the rules of AGMs, provided everything's done in accordance with good guidance. And secondly, it is fairly clear that the government hopes this Act is retrospective, and no one really wants to argue that it isn't. So there's a good chance that these charities should be okay. Nevertheless, in all cases of AGMs, it's important to remember 4 things. Firstly, when charities are considering postponing an AGM, they should check that the authorisations given last year last for more than a year. Sometimes authorisations are only given for 12 months at a time, and once that period expires, then in theory, the authority is lapsed. Secondly, the 2020 Act doesn't abridge the duties to provide full and timely information to people who can vote, nor does it affect the rules on the quorum for a meeting. It's simply about the mechanism for holding a meeting. Thirdly, particularly for important decisions, trustees should take detailed minutes of any remote meetings, and in my view should record whether there are any technological glitches, things like lag or disconnections or an inability to share screens, just so that things cannot be challenged at a later date. And finally, in my view, it's probably worth having a practice remote meeting before the official AGM, just so people can get the hang of using the software and interacting with each other and voting if necessary. My final topic of the webinar is shopping. About a month ago, shops were allowed to reopen subject to certain rules. Personally, I'm hoping for a lot of photos with some excellent lockdown facial hair, much like this genuine chap here, but that might just be me. Helpfully, the Charity Retail Association has produced an excellent 33-page guide on what charities could and should do when reopening their shops. It breaks down its recommendations into mandatory guidance, strongly recommended advice, and issues which should be considered by a charity. As to the content, it covers things from the building itself, the people in it, including staff, volunteers, and customers, operating a shop, and then marketing it. The guidance also has lots of useful tables and checklists to help a charity work through the whole process logically and carefully. Now, because the guidance is so long and detailed and well written in my view, I'm not going to say anything more about it now, but you can use the link on the slide to read into it further if you need to. This is a question from Claire. If an unincorporated charity does not have the power to hold a virtual meeting and cannot amend its governing document to include that power, is it still technically possible that a member could challenge the validity of the meeting and any decisions made, even if the trustees had followed the Charity Commission's guidance? In my view, in theory, yes. But in practice, it's unlikely, in my view, that that challenge would get very far, as long as the trustees can show the general rule of good guidance and that they had complied with the Charity Commission's suggestions as to what should be done in these situations. In a nutshell, what that will involve is the trustees writing as much as they can down about their reasons for doing things, how they've done things, and how it turned out. For example, the people who are likely to be challenging these things are probably the people who are likely to have difficulties with attending AGMs. So it's important, as I said, to have practice AGMs or clear instructions on how everyone can join in, just so they don't feel excluded or like the process is going around them or not involving them. So the short answer is, in theory, yes, but hopefully those challenges wouldn't succeed. I also received a question in advance that I've written down from Abdul, and it says this: I have a COVID-related question relating to organising fundraising events such as fetes, bazaars, and similar events. As we emerge from lockdown and charities will need to raise funds, what is your view on charities holding such events, especially if they are outdoor, and if they go ahead, what measures should they put in place? Or would the current risks outweigh the benefits of holding such events? Now, as far as I can tell, the relevant law here is the rather snappily titled Health Protection Coronavirus Restrictions No. 2 England Regulations 2020, and in particular Regulation 5. What the government seems to do is just produce new regulations every time it updates its guidance to the public. And this appears to be the guidance that was produced on the 4th of July, when the Prime Minister announced that restrictions were slightly easing. Those regulations say that it is possible for charities to organise larger public events outdoors if the event is, and I quote, reasonably necessary for work purposes or for the provision of voluntary or charitable services. Now, in my view, it's not entirely clear if that would permit fundraising, but on balance, probably not in my view. So when you look at the list of exceptions, it includes education, training, childcare, emergency assistance, and avoiding injury or illness. All of these things are direct services to the end users. They're not ancillary business purposes like fundraising or generally trading. So in my view, probably on the current reading of the guidance, charities cannot simply arrange large fundraising events outdoors. But I couldn't find any concrete guidance either way. That's just my reading of that very specific regulation in essentially an untested set of rules. But in any event, even if you can arrange outdoor events, I think practically it might be difficult to get large crowds just because people will be concerned about the risks of such events, particularly with things like fetes and bazaars. It's not like a concert where everyone can stand in one place, for example. The whole point is people are milling around, going from stall to stall, interacting with each other, handling goods, getting involved in games, and so on. So the short answer is I think you've got to be pretty careful here. So Anne has asked, is there any news about an extension of the 30th of September cutoff under the CIGA, the 2020 Act? Charities with AGMs due before the end of the calendar year may be cautious in wanting to hold physical meetings. And I think you're exactly right. Charities will feel cautious and should feel cautious. As far as I'm aware, there hasn't yet been discussion of the extension, but as far as I can tell, often these extensions come quite last minute. You may have heard of the restriction on possession orders that was introduced in March. That was originally for 3 months until June the 26th. And I think it was only relatively early in June that the government extended that until August. So what will probably happen is the government will take another view at the start of September and then decide whether or not to extend the time further. But beyond that, I'm afraid my guess is as good as yours. Anonymous has asked, do the AGM meeting points you have made also apply to trustees' meetings? Now, I think I should probably clarify what I was saying. So the two AGM points were for unincorporated charities or for incorporated charities. So obviously the incorporated charities, you go down the Act route and rely on that. But under the Charity Act, pretty much all of these people are called trustees. So I think the answer really depends on what type of charity it is. If it's an unincorporated charity, then the points on my unincorporated charity slide apply to those trustees. But if you're an incorporated charity, a company, then you go down the incorporated route under the 2020 Act. I hope that's what you meant.
I was just asked what did happen with costs in the Fafalios case. And the answer is that costs came out of the Cemetery Trust Fund. Given the extremely hostile nature of the litigation in the minds of certainly the cemetery trustees, this came as something of a surprise, but the judge decided that given that the 1935 deed had stayed unchallenged for so long, it was not appropriate to treat it as anything other than a construction, a genuine construction case. So, and I can't immediately recall what the cost bill was, but it certainly wasn't negligible. So again, thank you very much for attending and I hope to see some of you in the future. Goodbye.